Hello, everybody. Welcome to the Inside R&E podcast, where we explore the ins and outs of real estate in New York City. I'm your host on this episode. My name is Ben Williams. I'm a member of Rosenberg and Estes, and I lead the property tax department here. I handle property tax certiorari and property tax reductions, and I am a recovering appraiser or former appraiser. I used to specialize in valuing property, and now I do tax certiorari of it, which is arguing assessment reductions based upon the value of the property. Today, I am joined by two friends of mine and experts in their fields, Neil Axler, and he is a managing director at EisnerAmper, and also Brett Theis, my partner at the law firm. He's a litigation member, and we are going to discuss appraisal methodologies, commercial lease appraisals, arbitration, and litigation and how they relate, and some property tax issues that we thought our viewers might be interested in. So let's start with Neil. Neil, thanks for being here. Welcome to the office building. We know your firm just moved into the same office building as ours, which is pretty exciting. Neil, you're an appraiser. How long have you been an appraiser?
Hi, Ben. Thank you, Ben and Brett, for inviting me to this. So I've been an appraiser for over 30 years, and I knew you from your life before you were an attorney. So it's great to be here.
What kinds of appraisal assignments do you handle typically?
So I lead my firm's national real estate valuation practice. So we value all types of properties. It could be commercial, residential, industrial type properties, institutional properties, and very immaterial small properties throughout the country. And I always joke that in New York City, I really enjoy looking at residential co-ops because these are buildings that if I wasn't appraising them, the doormen would not let me into it. So it's always fun to do residential appraisals.
I'm sure you see some interesting things when you are doing tours of the apartments.
It is. It's interesting and just a great. I started out in residential real estate. I grew up in Philadelphia, and I was working there, and I moved on to commercial real estate. But having understanding residential real estate is pretty important, and so many of my clients, whether it's it would be a litigation situation, a matter for matrimonial, I get a lot of calls about residential.
So if you're doing residential work and valuing co-ops in New York City, are you being engaged by the divorce attorneys?
Typically, yes, the divorce attorneys would, and I'm sure, Brett, this is how you guys do it as well. We would get engaged by the attorneys directly, so there's client confidentiality and so forth. So that is typical, but sometimes this could be a neutral appraisal, and the attorneys want to stay out of it, and we just engage the each party together.
Okay. Tell me about the distinction between those, because I don't know that our viewers would understand that. I think what you're saying is sometimes both the husband and wife would each get their own appraiser to do the evaluation, or sometimes they both agree to hire one person to
That's
do the
right.
valuation and whatever that person decides. Could you go into
That,
that?
Yeah, that's right. I think again, it's whether it's a mediator or actual litigation attorneys. Sometimes the parties will agree to have a neutral appraiser. So they'll both split the fee and get one appraisal, and they will then agree upon whatever the appraiser said. And I always like to do those because if both parties are unhappy with my value, then I probably did it right. So I find that to be good. The other side of the coin is when there's two opposing appraisers, where each side will get an appraiser to value the property, and then they will fight over it and do some sort of expert testimony and so forth.
Okay. How do you value a property?
So there's a methodology that appraisers use, which essentially has three different methodologies, and I'm sure you remember from back in the day. There's the sales comparison approach, there's the cost approach, and there's the income approach. The sales comparison approach is used mostly for residential properties. And sales approach is when you're looking at comparable sales that have occurred, transactions, and then you compare them to the subject and you make adjustments for the differences in the property to come to an understanding of what the market value should be. The cost approach is when you value the land and then you come up with replacement costs. What would it cost to replace and build the property today? And then you depreciate it based on its current age and functional and obsolescence and so forth. And then lastly, the income capitalization approach. And that's really the best approach to use when you're looking at income producing properties, because typically real estate investors, if they're buying an income producing property, they would measure what the value is based on how much income it can produce and so forth. So we typically try to do all three approaches and then come up with a reconciliation and come up with our value.
How do you obtain information about income and expenses and cap rates when you're doing an income approach valuation of a commercial income producing property like an office building or a 100-unit apartment building, rental building?
So that's a good question. Typically, the income approach is difficult in the sense that with a sales approach, you can go and sales and transactions are all recorded in most states, and you can get comparable sales, and you could look at a deed, you could look at the mortgage, you could say, look, this property sold for this. For income approach, for income producing properties, everything is confidential. So what we do is the property we're appraising, we look at their rent roll and we look at their financial statements and we get an understanding of how that property is doing today. But then we look for comparable rents and come up with a market rental value and other inputs to our valuation model. And getting that is typically done through looking at surveys, looking at some databases that we have. But in reality, it's calling as many market participants as we can, whether it's a real estate broker, whether it's a real estate attorney who's doing deals, whether it's a developer, other sorts of investors. And we try to come up with what the fair market rent should be, what expenses should be, and cap rates and what they should be. And then we take all that information, we make sure in our report it's supported by all those different factors, and then we do our valuation model.
And you've done, or let's talk, I want to ask Brett now. Brett, you've hired appraisers for some of your cases. So first of all, why don't you introduce a little bit about your practice and what kind of litigation work you do and enjoy doing, and then I'd love to hear how you have used appraisal reports in some of your litigation disputes.
Sure. Thanks for having me, Ben, and hi, Neil. I'm a commercial litigator. I represent owners, developers, management companies, all REITs, all sorts of people in the real estate game. And I've been doing it for about 17 years now. And so in my practice, when I have occasion to use an appraiser is most frequently when I'm dealing with a lease dispute. And it arises when a commercial lease, let's say, has a term that's expiring, but the tenant has a renewal option. And the tenant exercises that renewal option, but then the question arises, all right, what's the rent going to be for that renewal term, whether it's a 5-year term, 10-year term? I've seen 20 and 30-year renewals, and even more. So you look at the lease, and the lease might say, well, if the parties can't agree on the fair market rent for the renewal term, they're going to go to arbitration. And these lease clauses will typically have one of two, I think, are the most common ways to determine it through arbitration. It's either baseball arbitration or a traditional arbitration at AAA or JAMS where you actually have hearings. So when I have a client that comes to me and says, hey, my tenant just exercised its option and it's a fair market value option, but the lease doesn't specify what the rent should be during the option term, it talks about arbitration, what do I do? So the first thing we do is we go out and get an appraiser, such as Neil or some others that I've used. There's I would say a fairly small group of people that I've had experience with, and they all sort of know each other. I don't want to call it a boys club, but it is a little bit of a club, and they all tend to be members of the Appraisal Institute. So we go out, we retain the appraiser on behalf of the client, and then the appraiser gets to work. And of the 3 methods that Neil mentioned, what I've seen, like if say it's a restaurant lease, what I've seen is the sales approach. The appraiser goes out and does his or her diligence in the marketplace, tries to find as many comparable leases as possible in the same, not just the same market, but the same submarket. And they try to get as many different comps as possible. And then they verify the information. They try to get the leases to the extent they can get the actual leases. And if they can't get the actual leases, they will talk to brokers and owners and try to get them to verbally confirm what the terms of the leases were. And then it's going through a series of adjustments. You compare the property that you're appraising or the space in a property that you're appraising to other properties, and you adjust upwards or downwards if the location is inferior or superior, or if there was a lot of allowances given to the tenant for improvement work. And the idea is to try to get to a unit that is equal across all categories that you can compare and then arrive at a value. So I've had a lot of experience and a lot of fun actually dealing with appraisers, because they'll be the first ones that tell you, and I'm sure Neil you can relate to this, that it's an art and it's not a science. So there's gray area, there's wiggle room, there's areas to use judgment and, I don't want to say opinion, but opinion based on real world experience to kind of come up with your value. So it's a really specialized process, and I feel like you need an attorney. If you have this type of an issue and you're an owner, you need an attorney who has done this before, who has relationships and connections with appraisers. And then once you have your appraisal report, you look to the lease to see what you're doing. Are you doing baseball arbitration, which is one method, or is it a real AAA, arbitration process where each side shows up with their appraiser and their appraisal report. Sometimes the appraisers get the opportunity to do rebuttals, and then you have a hearing and you call your witnesses, and at the end of the day, you're trying to convince a neutral third-party appraiser that your determination of value is correct and the other guy's wrong. If it's the hearing context, like I was talking about, the appraiser will not be bound by one or the other reports. I'm sorry, the neutral appraiser, who's basically your arbitrator, but they get to determine what their market value, what they think the market value is. And then once you get that arbitration award, you can go to court and confirm it, and it has the effect of a judgment. If it's baseball arbitration, it's a little bit easier and a little bit different. But essentially, each side presents, their own appraisal and determination of value to a third-party neutral, and the neutral picks one or the other. They can't pick a gray, a spot in the middle to try to compromise. They have to pick one or the other, whichever they feel more closely resembles fair market value. And the reason that people do that and tend to, like to do baseball arbitration is it keeps everybody honest, because you can't come in with a crazy determination of value that's crazy high, because the other side might not come in as far from the middle as you are, and you might ultimately lose, I guess, under the saying, pigs get slaughtered. So baseball keeps everybody honest, and it avoids some cost and expense of actually doing a hearing too. So, and there's every piece of what I just discussed, there are nuances and different avenues that we could go down and really get into the weeds, but generally that's how I've used appraisers in my practice, and I've had really good experiences.
If I could jump in real quick, Ben. Brett, I'd say this is the first time in my entire career I've heard someone use the word fun and appraiser in the same sentence. So this is fantastic, and I'm glad I know you. But it's funny, when I was preparing for this call, I got a call from a client of mine in the Pacific Northwest, and I've done a lot of work for supermarket chain. These really rural areas, but these are supermarkets, and we helped them years ago when they were doing an ESOP. So we valued all of the leasehold interest because they leased this big portfolio of supermarkets. So I got a call that exactly what you do. They need to figure out what the market rent's going to be with their lease, and it's an assignment that I'm probably going to do, but it's going to be a horrible. I don't think it's for litigation at this point, but it's just a horrible assignment, because getting supermarket leases in the middle of nowhere. I mean, this isn't Manhattan with retail or office or whatnot. It's very difficult going to be very difficult to come up with some sort of market rent for them. So for me, it's all about how do you get data? How do you have access to good data?
Yeah, very important. You need that. And you raise a good point. And a lot of the litigations that I've handled have been in Manhattan. And so comps are easy to come by. You can cherry pick the good ones and ignore the bad ones. But there's, especially for restaurant leases or, an office lease, there's more than enough comps to go around.
Are brokers helpful in getting that information?
I'll let Neil answer that, but I guess since I jumped in anyway, I think the brokers are helpful to the appraisers. The appraisers will speak to the brokers and find out leads and ways to get information. So I do think brokers have value, but when it comes down to doing a hearing on fair market value in front of an arbitrator, my preference always is to have a certified appraiser who's a member of the Appraisal Institute.
And that's a good point. Brokers, they provide a lot of the same services that appraisers do, but they're not appraisals, they're broker price opinions. And it comes down to the quality of the broker as well, and how much some brokers are better than others. And the biggest thing I get emails all day long from friends of mine who are brokers and talking about how lousy the office market is really doing, in New York and throughout the country. But you hear all of these brokers out there and these brokerage firms saying that things are great. So I think you need to make sure when you speak to brokers that you speak to enough brokers and can support as much information that they give you.
And another point, the difference between broker and appraiser is appraisers, especially a member of the Appraisal Institute, is going to be bound by a set of rules or a set of canons called it's called USPAP. Neil, I don't know if you could help me out with that acronym, what it actually stands for, but I know it's a very comprehensive set of rules that govern an appraiser's work.
Exactly. And I'll tell you what it means, because maybe this will be more fun for you to learn this. It's the Uniform Standards of Professional Appraisal Practice, right, Ben, if you recall. And it's true.
Yeah, I have to take it.
Oh, yeah, you're still taking it. So it is true, though, when I am trying to convince a client to use us rather than use a broker price opinion, that's part of our sales, saying, look, we have standards, we have guidelines and so forth, continuing education that we need to abide by. And brokers often can use a broker price opinion, sometimes for a loss leader to maybe get the listing on the flip side. So where appraisers, it's strictly an independent fee and assignment.
Right. And you can't, as an appraiser, the value you come up with has to be unrelated to the fee that you charge.
Yeah, exactly. And that's, Ben, I know you and I have done some work together, and oftentimes your fees are different than the way that we would do our studies. So for us, it's got to be an independent. We're not, similar to the neutral matter that we were talking about earlier. We're, we have an assignment, and it doesn't matter how much the value is or who successfully wins. We get paid regardless. So this way we can be unbiased.
Right. Right. Unless you just don't get paid, and then you're chasing your client for the money, right?
Exactly. And then I would call
Right.
other lawyers in Rosenberg and Estes.
You can call
Right.
me in that circumstance, Neil. I can help with that too.
Good. I'm
Have
gonna
a
do
knack
that.
for finding money.
Brett, do you use USPAP for like Daubert challenges or voir diring to try to undermine the credibility of the other side's appraisal?
Yes. I've done that at a hearing before, at a AAA hearing, where the appraiser was doing things, in my opinion, that violated USPAP. So I would impeach him with his own rules and elicit, an admission from him, probably unwittingly, that USPAP was not followed in that circumstance. I guess one instance I can think of, and it's kind of nuanced and it might be a little difficult to get through, but there's an issue with, I think it's called the date of value. So a lot of times when a tenant exercises a commercial lease, exercises a renewal option in a commercial lease, you might be into the renewal term before the arbitration even gets going. So then you're having an appraiser come in, and you're asking the appraiser, okay, you have to pretend that it's this date in time, which might be 6 months, a year ago. And you have to determine what the market value was as of that date, but you can't use data that would not have otherwise been available to you. So if some major lease deal was signed, 6 months after the date of value, can you look at that? And I think USPAP says you can't, except for in one or two very limited circumstances. So that was the instance in which I was able to successfully impeach an appraiser during an arbitration for not using USPAP, not following his own rules that they signed up to follow.
Neil, do you ever get hired to do appraisal review assignments?
We do. And also, I want to jump back to Brett, what you just said about that USPAP violation. I mean, the whole issue of USPAP really is not to be misleading. And I think that's was very misleading if they're using market data that happened that they wouldn't know about back then. So I think that's probably where you had success with that. We do get hired sometimes. I don't spend all my time doing litigation, but occasionally we would have an opportunity to just be the reviewer for a litigation matter. So I think there is a role. So Brett, it sounds like some of these leases are written that gets a each side gets their own appraisal done, but then the third party ultimately gives a decision. So I would assume they would review both. We do review if we're doing expert testimony and we have to do a rebuttal. We would review for other non-litigation work. We'll do a lot of review. Since I work for an accounting firm in the same building as you guys, a lot of most people in my office are not appraisers. They're auditors and accountants, and a lot of what they do is look at the real estate auditors. They have to look at the appraisals that were done by the client. So our group would come in and do reviews, and we would look at it for similar to what violations like you're talking about, and we would look about methodology. We're not going to look too much about. We're not going to redo the appraisal, but we're going to make sure that they're doing a good job that seems to be consistent, not misleading, and so forth.
Yeah, another area where I had some success impeaching an appraiser was in his report. He included, I don't know, they have these charts and they have, 20 different comps with all the adjustments, but, 3 or 4 of them were not, or I guess I should say were admittedly asking rents. They weren't consummated deals. And there is case law in New York that you really cannot consider asking rents and give them the same, consider them at all in fair market value determinations. So, I don't know if maybe not all appraisers know about that, but if I got a draft appraisal report from my appraiser and had asking rents in there, I'm striking them immediately.
That's really interesting because I think, most appraisers, unless they do this all the time, are not going to know about case law specific for each jurisdiction. So they're going to rely on a good attorney like yourself who would make sure to tell them that, look, you can't use listings. From the appraisal side, though, it's pretty tough because, as I mentioned before about confidentiality, unless you get a copy of a lease to use as a lease comp, a lot of it's going to be hearsay. It's going to be a listing or it's going to be a lease that a broker's told you, yeah, this is what it is, but you're not going to have it's not like having a copy of the deed. You're not going to, so personally for other matters outside of New York or just for other appraisal, we use listings all the time because to us, you can't get a better indication of what's going on in the market right now and seeing what's being offered, and then we'll discount it and we'll say, look, ultimately they're likely to get a lower rent once it's consummated, but listings for us are really, really good.
Interesting. And I've done some fair market rent valuations that have not been in arbitration and that have been in front of a judge. I had one before Judge Sherwood, now retired Judge Sherwood, but the hearsay rules are much more relaxed in arbitration. I don't want to say almost anything goes, but really almost anything goes. In court, that's not going to work. You need to present real evidence and have real proof that there was a lease signed next door and it was $110 a foot, and that the court can rely on that in making a determination. Arbitration, like I said, is much different. Arbitrators, unless you have a clause to the contrary in your lease, arbitrators don't even really have to follow New York law. They can they're supposed to do whatever they think is fair and just. Which is why sometimes if I'm advising client on commercial lease clauses, we'll put in there that the arbitrator must follow New York law.
How do you decide if a case is going to go to arbitration or to trial? And I mean, I assume the answer is whatever they wrote in the lease, but how do you decide, if you're going to write it in the lease or not? And why do these disputes even come up? Why do people leave the renewal term rents so open-ended and then it becomes a big battle as opposed to negotiating something or coming up
Yeah,
with a formula? Have you seen a lot of different versions?
yeah.
And how would you advise people entering into a lease today for a property so that they can, I don't know, maybe minimize the hassle later?
So yeah, all good questions, and there were a bunch of questions in that compound question that you just laid on me.
Hmm.
So let me take one of them. Um, I I think it can be a function of it's definitely not laziness, but it's just hard to determine when you're negotiating, especially right now, trying to negotiate even getting a 10-year office lease signed. It's tough. And so to decide what the rent is going to be, if there's a 5-year or a 10-year option on top of the existing term that you're granting. So a lot of times people will say, well, it should be whatever the market is. And that seems like, it allows you to get a deal done without having one more thing to negotiate, which is very tough to negotiate because it's going to be very speculative. Now, sometimes you can agree to, that, maybe the rent for the first 10 years will have 3% increases. And then if the tenant exercise, there's a step up and then continued increases. If you can get that, maybe that's good, maybe that's not. But what I'm seeing more often than not is both parties agreeing to say, we'll figure it out. It'll be whatever's fair at the time. And then they don't often realize what figuring it out entails. You could end up in court. You could end up in arbitration. It's why you need a good arbitration clause, or you need to consider the issue. Do you want to go to arbitration at all, or do you want this to stay in court? Court has its advantages and disadvantages depending on if you're representing the tenant or the landlord, and vice versa for arbitration. So I don't think there's any magic or specific formula. Every deal is going to be different, and right now in the market, it's a challenge to get deals done. So if you can take an issue off the table and kind of kick the can down the road, I've seen clients do that, and I'm fine with them doing that, but they have to understand what they're doing, and we can build in protections in the lease that the other side might not actually be focused on at the time, which will come in very favorably, for my client down the road.
Brett, what side are you usually on, or does it not matter? Tenant or landlord?
Oh, we're 90% landlord side. Yeah,
Okay.
our client base is landlords, owners, developers, institutions. We definitely have and still do and enjoy representing, commercial tenants. Where I think it's just not the majority of what we do.
Wow. So you don't write in the lease, both parties agree to hire Neil Axler as their appraiser, and whatever he says, that's what we're going to go by. That would be an easy way.
Well, not specifically Neil, although after this conversation, I'd happy to put his name in a lease. But you can agree.
Here, let me show you how to spell it. Okay, it should be listed on there. Okay.
Yeah, you could agree to, a person with a specific set of qualifications to be appointed by AAA, somebody with, more than 20 years in commercial real estate leasing, so that when this issue comes up, you could submit to AAA. They give you a name. Each person submits and that's kind of what baseball arbitration is. So that does happen. I do not recommend tying yourself to one person and putting in. I know you're being, you're joking,
Yeah,
but I
joking,
don't.
yeah.
That's not something I would do or ever see a specific. I can't say I've never seen it. I have seen it, and actually, in that case, the person was no longer with us. So that, one
I
of
made
the
it
obvious
hard.
ones there.
You need a seance. Brett, I guess it's dependent on how busy you are with how the market's doing, right? Because I would think if landlords just want to have a tenant in there, they're going to do whatever it takes to get them in. And regardless, whoever has the leverage, or are you pretty steady regardless?
Yeah, we're very well positioned that when, at least in my practice in litigation, which also I do some transactional work, but when the market is bad, we're busy, and when the market is good, we're even busier. So there's a lot of work that our clients need us to do, no matter what the market is doing. And I think that's kind of a testament to our firm too. We're a one constant, right? They can always come to us. Okay, this is what's going on. It might be a great thing, and we help them figure out how to make it even better, or it could be a terrible thing, and we help them, mitigate their loss. I am a litigator, but I do feel like my clients consider me an advisor to them, and we always have their back. And thankfully, knock on wood, there's no shortage of work.
That's great.
Would you handle fair market rent resets for like a small restaurant, or is it more common to larger type spaces or ground leases? Like, what's the typical deal look like? What is it for?
So the one I did most recently was a small size Irish pub in Times Square. I represented the landlord, um, but it wasn't a massive site or anything. It was one restaurant lease, um, but it had a very odd and I would say off market renewal option, in that I think the renewal term, if exercised, and this tenant did exercise, was something like 30 years. So the appraisers had to figure out what the rent would be for the next 30 years. So
Wow.
the economics there in Times Square, and this might have, I think it was the only retail space in my client's building. So it has a massive impact, on everything that they're going to do. Um, so yeah, we do whatever our clients need us to do, no matter how big or how small. And even the small things, when you actually examine them and consider the financial impact, they can be quite large too.
And the upside of that is it's an Irish bar. Everyone's going to want an Irish bar for the next 30 years. I mean, come on.
Yeah,
It's New
but the
York.
downside, I agree with you, but the downside of that is we did well on getting the rent reset at market for Times Square, and that Irish pub is no longer there.
Hmm.
There
They,
you
they
go.
could not they
Yeah.
could not afford the increased rent.
Yeah.
Yeah.
Yeah. Neil, what kind of work is your favorite to do? What do you like to do? What kind of cases do you want? If people could bring you appraisal business, what do you want to be doing?
I love tax appeals. I love attorneys that do tax appeals like you, Ben.
Right, right.
No, but in all seriousness, it is nice when people need an appraisal that it will benefit them and help them somewhat. Whether it's a partnership dispute, we deal a lot with trust and estates where there's family partnerships, and unfortunately you've got the dysfunctional families, and there's each sibling is suing each other. It's nice when you're helping someone out. You're still being independent and giving a non-biased, unbiased appraisal, but it is helping somebody. The other nice, it's locations. I gotta say, we do work all over the country, and as much as I love looking at a steel mill in Iowa, I enjoy valuing macadamia nut plantations in Hawaii better. So
Mm.
it's fun. It's always fun to get a fun place, whether it's something in LA or some more fun work than maybe looking at some sort of landfill or something.
Do you always go and do a site inspection?
Yeah, the way I've written into my contracts with my staff is I get to go to the nice places and I send them to the landfills and so forth.
Hmm, hmm.
But the answer is
Now,
yes, all right? Somebody always goes to physically inspect. Is that correct?
We try, and that's a good question. During COVID, and I know Ben, you and I spoke a lot during COVID when we were all in lockdown, and um, clients got pretty used to us not looking at properties. It was obviously much cheaper. We didn't have to travel to look at the property. We got it done quicker with technology. It's much easier to do it and not look at it. We try to look at as many properties as we can because whether it's a litigation matter or a IRS or an auditor who's going to be questioning our reports, so many questions can be answered by saying, I physically went to that property and I saw this, I
Yep.
saw that. The access, even in New York, when I do properties, we walk past them because, block by block, everything's different. And if you could say when I was there and I saw the scaffolding or potentially there were people in the neighborhood who shouldn't be there and doing things that are not great for real estate values. It's important if you say, "Look, when I was there, I saw this and that." So inspecting properties is super important, and it doesn't just have to be Hawaii. We look at anywhere in the country and as much as we're able to. But nothing in USPAP though says you have to inspect the property, but again, you cannot be misleading. So if you look at a picture and you appraise a property and that property burned down and you didn't know that, then you're violating USPAP. You need to somehow confirm that the property is still there. And you could be very misleading if half the property burned down and you're valuing it as if it's fully there. And then your value is going to be higher than it should be. So it is important.
Yeah, I agree with that. And I take it even one step further. I will require my appraisers to not only physically inspect the subject premises that we're appraising, but if we're relying on any comps, I make them go out and look at the comps down the street where they're saying that 3 buildings down, the owner just signed a lease with Buffalo Wild Wings for 100,000 square foot restaurant, and this is the rent that they got, and this is comparable. I want them there for exactly the reasons Neil said. Just especially at a hearing before an arbitrator, it just carries so much more weight to say that I was there and I saw
And
this.
restaurants are great. You could walk inside, you could have a beer, you could look at the tenant improvements, you can look at, it's not like an office that you can't get into, but
Yep.
anything that you have a public space like a restaurant, you should go take a look at it, especially in New York, where they're going to be only a few blocks away.
Yep. Agreed.
yeah, Neil and I got to work on a matter together recently for one of my clients for a property tax protest. It was a single family home in the city. And in New York City, for tax assessment purposes, homes, 1 to 3 family homes are, I mean, and vacant land too, but mostly 1 to 3 family homes are the only type of property that are valued based upon market value. How much is it really worth? Income producing properties are valued using a direct capitalization of income, and it doesn't have a relationship to real world market value based upon how buildings sell for. So I had hired, or our client had hired Neil to value his house, and the city had said it was worth over $10 million. And Neil, and I had looked at some comps in the area, and I thought maybe it was not worth that much, and that we might have a good protest, but to convince the tax commission and hearing officer that it was overvalued, I thought it would help to have a real appraisal report from a real life appraiser. So, we hired Neil, and he went in and he uh, Did you inspect the property or was that a drive-by?
No, no, and that's funny you brought that up. I remember inspecting that, and
Mhm.
those are always great because you're inspecting it with the homeowner who's telling
Hmm.
you everything wrong about the property. He's telling you how
Right.
bad it is. He's not trying to sell the property and say it's the greatest thing. And he's like, look at this basement, look at this leak. They never fixed this. They said they were going to do this. And again, you can't be swayed by what they say. We do a lot of
Mm.
estate appraisals, and it's the same thing. The owners say, "Oh, it's so terrible. It's come inspect it on a rainy day, please, so all your pictures look gloomy and whatnot." But it is important when you by me walking through that property with the homeowner, and I had to take notes of what he was talking about, but I had to kick the tires and say, well, he's obviously very emotional about this because he's spending, it's very costly, and when you own a property for your residents and things are terrible, you get emotional. But I have to look at it from a market value, and a lot of what he said was right. So that was a great example of one that we should have inspected, because if we didn't, we probably would have missed out on a lot of the nuances.
Yeah. Yeah. And in that case, I mean, I have other buildings in New York City. It's not a slam dunk to get a reduction, and actually less than 20% of protests get a successful settlement and reduction in their assessment. I had a building that a house, and we had an appraisal report and a same property sale, a fair market sale, arm's length sale. The guy bought it, and his appraisal report for financing also happened to tie out to about what he paid for it. And the tax commission still thought, oh no, we don't think that that's the right value. We think it's worth a lot more. And so we had to go to court and eventually settle it at the pretrial level. Years later, it took years to get the result. And they don't pay interest. The city won't pay interest
No.
unless there's a determination after trial, like the judge issues an order, and then the city has to pay interest. But most cases, most tax cert cases in New York City never go to trial because we have the tax commission. They're very good about settling good cases. Yeah, there's some that slip by. Um, you know, so uh, that's just kind of how why most appraisers aren't doing work for New York City property tax protests right now because we're
Interesting.
we're, set, we're settling the cases that can be settled. Yeah. So I expect more office buildings. The city's a little reluctant and I just read the comptroller's report. Vacancy rates are still high,
Oh
and
yeah.
and the amount of TIs that landlords have to give is at its peak, right? So yeah, maybe face rents, asking rents are still about where they were at before, maybe a little bit less, but vacancy rates so much higher, TIs are so much higher, costs
They're
a lot
giving
more.
free rent. They're giving a lot of free rent. So
Yeah,
whenever you
a
hear
year of
about
free
something
rent,
getting leased, yeah,
$120 a foot in TI for a 10-year lease, and after the space was vacant for a year or two, right?
Are you seeing
And then they're
many?
going to go in paying $70 a foot, and the tax commission's going to say, "Oh, it's $70 a foot." Like, well, wait, what about all the other stuff too? Right,
Yeah.
right. It's um, so having appraisers to give estimates is helpful. So. Um, I wanted to thank you both for coming. I wanted to leave it open if there's anything else you wanted to add or say.
No, this was a great discussion. Thank you both for having me.
yeah. Thank you as well, Brett and Ben. Thanks for moderating and putting on a tie and making us look bad.